Peace, everyone. Peace, peace, peace. Happy Wednesday. Today is October 12th, 2022, according to the Gregorian calendar. And I am Empress ShayMarie, back for another recording. Wanted to continue on with this amazing book that obviously I should have been read. But today we're going to be continuing on with Gilbert Law Summaries. So I'm going to go ahead and share my screen. And we're discussing the topic of trust. Okay, so this is a summary by Edward C. Halbeck, Jr. Okay, and we're going to pick up on chapter 2 today, which is on page 70. I hope you've been able to go back and review the first 2 recordings, which covers, the beginning up to chapter 1, going over a lot of amazing, great things. So today we're going to go over expression of trust intent, express trust and how to express the trust, or what is express trust. We're also going to talk about trust property or trust res. We're going to talk about parties to the trust, and we're also going to talk about trust purposes. Okay. So starting out is the key exam. To determine whether a trust relationship exists and to understand the trust relationship, look for the essential elements of a trust. Number 1 is trust intent. If an exam question leaves any doubt about the required intent to create a trust, remember that the manifestation of intent must be timely, and the use of or failure to use the term trust is not controlling. In particular, watch for questions that involve precatory language. Such wording today is presumed not to express a trust intention, but a contrary conclusion can be based on the questions, facts, and circumstances, which should therefore be carefully analyzed. Number 2, trust res. There can be no trust without trust property. That subject matter must be presently existing property, which can include future interests, and it must also be specific and identifiable. Number 3, parties to trust. A trust must also have a trustee and one or more beneficiaries. Remember that courts will appoint trustees if needed, but in questions about trustees, be sure to consider both legal and practical capacities to serve, and watch for the existence of grounds for removal, as well as liabilities considered in Chapter 6 of this summary. B, for private trusts, there generally must be identifiable beneficiaries. Questions in this area are likely to focus on 1, the requirement that if the trust beneficiaries are to be selected by a trustee, they traditionally must come from a reasonably definite class, and 2, whether a power holder has a duty, i.e., imperative, to select distributees or merely a non-mandatory power to do so, which is not a trust and does not require definite beneficiaries, and therefore can offer salvation, even under traditional doctrine, when a class is indefinite. C, absent identifiable beneficiaries, look for a charitable purpose. See Chapter 5, or in some states for the limited possibility of sustaining an arrangement as an honorary trust, or as a trust for an allowable non-charitable purpose. Number 4, Trust purpose. Watch for the existence and consequences of trust purposes that are impermissible because they are illegal, tortious, and contrary to public policy. Such issues tend to focus on invalid conditions, which attempt to impose improper restraints or inducements on a continuing basis through the trust device. B, if your exam encompasses perpetuities matters, watch for any problem of remoteness, of vesting, or accumulation. Introduction. Number 1, requirements in general, Section 62. The usual elements of a trust are 1, trust intent, at least an express trust. Number 2, a special trust res, which is property. Number 3, designation of the parties, whether it be settlor, trustee, and beneficiary. And number 4 is a valid trust purpose. So these are the 4 elements of a trust: trust intent, special trust res or specific trust res, a designation of parties, settlor, trustee, and beneficiary, and a valid trust purpose. Number 2, exceptions, Section 63. As discussed below, there are some trusts in which there is no real expression of a trust intent, resulting in constructive trust. Also, the temporary absence of a trustee or even a present beneficiary will not destroy a trust, but a res, i.e., trust property, is essential in every kind of trust. There must always be a trust res. This underscores the fact that a trust is a relationship with respect to property. 3, consideration, Section 64. Consideration is not required to create a trust. In fact, most trusts are gratuitous. The significant role of consideration in some situations involving contracts to create trust is discussed in Section 293 Infra. Checklist of elements of a valid trust, which we just went over. So we'll discuss it again. It's to determine whether a valid private trust has been created. Look for the following characteristics: intent to create a trust manifested by settlor's words or conduct. Then it needs the trust property or res. The settlor has with capacity. You need a settlor with capacity. You need a trustee. A trust generally will not fail for lack of a trustee, but see Infra 137. Basically meaning that a judge or the court will appoint a trustee if one does not exist. Identifiable beneficiary or beneficiaries. And you also need a valid trust purpose, one that is not illegal, tortious, or against public policy. Expression of trust intent. B, express trust. 1, in general. 65. It is essential to the creation of an express trust that the settlor objectively manifests the final, definite, and specific intention that a trust should immediately arise with respect to some particular property. DeLuel Executors versus DeLuel, 1934. Restatement 3D 13 or Section 13. This does not mean that the intended trust cannot be revocable. Number 2, form of expression, Section 66. There must be some external manifestation of intention by words or by conduct. It is not enough that the settlor's intent was formed in her own mind if she gave no external manifestation thereof. So basically meaning write the vision and make it plain. Nor are vague expressions of donative intent sufficient. The settlor must manifest a specific intent to create as to some particular property a relationship known in the law as a trust. Citizens Trust and Savings Bank versus Tuffrey, 1918. Wording, Section 67. No particular wordings or words are required. The term trust need not be used, nor is it essential that the settlor or any other parties involved know or understand that the intended relationship is a trust. If the courts find that the parties intended to form a certain relationship with respect to the property involved, and if the law defines that relationship as a trust, then the party's intention to enter into the relationship provides the requisite trust intent. Number 1, use of term trust, Section 68. Parties may refer to their relationship as a trust, but if the requisite intentions are lacking or an essential element is missing and not to be provided by a court, there is no trust. Number 2, use of other terms, Section 69. Even if the parties proclaim their intention to create a bailment, agency, guardianship, or other relationship, see Section 28 through 61, the court may find their real intent was to create a trust. Restatement 3D 13 CMT B. B. Communication, Section 70. Provided there is some external expression, essentially some admissible evidence, the settler's failure to communicate the trust intention to the beneficiaries or others does not prevent the trust from arising. Example, an envelope found in a safe deposit box and marked held for my nephew, Thomas Smith Kelly, constituted a sufficient manifestation of intent to declare a trust of the contents of the envelope. In Ray Smith Estate, 1891. 1. But note, failure to communicate the trust intention may be some evidence that the settler did not intend the trust to take effect immediately and thus prevent its creation. See below. Or it may merely be evidence that the trust was to be revocable, or the intent to create an irrevocable trust immediately may nevertheless be found. Precatory expressions of intent. A. Intent uncertain. Section 71. Usually the settler directs or commands the trustee to manage the trust property for another, but on occasion she may simply express a hope, wish, or suggestion that the property be so used. This type of expression is called precatory language, whether precatory expressions create trust or only unenforceable moral obligations or or less obligations or less, is a matter of interpretation, a matter for the courts to determine what the transferor intended. Example, testator devises Black Acre to friend, quote, with the expectation that friend will use the property to take care of niece, end quote. Is friend obligated to make provisions for niece, or does friend take the money outright, free to disregard the purpose mentioned by the testator? If this is merely a request, friend may disregard it, and certainly there is no trust. If friend is obligated to comply with testator's wishes, there is a trust for niece's benefit, or possibly some other enforceable relationship, such as an equitable charge. See Section 48 through 57, and uncertainties about the other provisions of the trust become matters of further interpretations, including whether any excess not intended to belong to friend is held upon a resulting trust for testator's residuary estate. B. Early view, Section 72. One moment, please. Section 72. The older cases were inclined to interpret words of wish, request, prayer, etc., as creating trust, on the theory that the testator or grantor, while being courteous in expression, nevertheless intended to limit the transferee's use. C. Modern view, Section 73. In general rule, today is clearly otherwise. Courts are reluctant to infer the trust intent from precatory words. Therefore, such expressions presumptively create no enforceable obligation. Number one, rationale. For a court to find a trust, the transferor must have intended to impose a legally enforceable obligation on the transferee, not merely a request giving the transferee an option to use designated property for the benefit of another. A trustee cannot have uncontrolled freedom with respect to the use of the trust property, but must be required to manage it for another. Ponzolino versus Ponzolino, 1947 in Iowa. Pittman versus Thompson, 1983. And In Re Estate of Kiefer, 2000. And last but not least, Comfort versus Cantrell, 1941. Number two, construction, section 74. The words of a testator or transferor will normally be given their literal meaning, and precatory expressions will not ordinarily be interpreted as a gentle way of expressing a command. Other evidence of trust intent, section 75. When precatory words are interpreted in context and coupled with other factors, however, courts may find sufficient trust intent. Estate of Burris, 1961. The following evidence or circumstances may be relevant. Number one, definiteness, section 76. The court will examine the instructions to the alleged trustee to see if they are definite, specific, and detailed. The more definite, specific, and detailed the instructions, the more likely it will be held that a trust was intended. But such specificity or lack of it is not necessarily controlling. Comfort versus Cantrell. Fiduciary, section 77. The court will consider whether the instructions are addressed to someone who otherwise stands in a fiduciary capacity. Language addressed to a fiduciary, such as to one's executor or administer, is more likely to be treated as expressing a trust intent. Language addressed merely to a litigee or devicee is less likely to be held to express trust intent. Number three, unnatural disposition, section 78. The court will look to see if the imposition of a failure to impose a trust would result in some unnatural disposition or result, such as one of the testator's closest relatives or other natural object of her bounty would end up with nothing under the will. A previously supported person would be left in need, or a stranger would inexplicably end up with an extraordinary gift. Number four, time and place, section 79. The court will determine whether an absolute gift was made first and the precatory words were later inserted, often lessening the likelihood of the trust. A disposition initially made in unconditional terms is not to be reduced by later language in less clear terms according to some courts, or whether the words or gifts and the precatory language are included in a single sentence or paragraph, which may lessen the reluctance of some courts to infer trust intent. 5. Other circumstances, section 80. The court will also review whether the circumstances indicate that a trust relationship was intended. Any pre-existing relationship between the parties or other expressions of purpose or state of mind made by the alleged settlor that would seem to indicate a trust relationship was likely to have been intended. Example, same fact as in the example in section 71, except there is evidence that the niece had been depending on the testator as her only means of support during testator's lifetime, or alternatively, that friend had been relied on previously to carry out testator's objectives. These circumstances suggest that testator intended to impose enforceable obligations on, on friend as a trustee. Exam tip. If you encounter a fact, pattern, or on your exam in which the settler expresses a hope, wish, or mere suggestion that the property be used in a certain way, your professor is likely expecting you to raise the issue of whether the trust was formed. Such precatory language generally raises a presumption that the settler did not intend for there to be a trust. But don't stop there. Be sure to look for other evidence to rebut the presumption, such as definite and precise directions to the trustee, or 2, directions addressed to a fiduciary, or 3, a resulting or quote, unnatural disposition of property, or of property such as a close relative will otherwise take nothing if no trust is imposed, or for a pre-existing relationship between the parties that would indicate a trust was intended, such as the settler previously supported the intended beneficiary. A court presented with such evidence is more likely to find sufficient trust intent. Time when trust intent must be expressed. Section 81. The general rule is that the intention to create a trust must exist and be manifested by words or conduct at the time when the settler owns or is transferring the intended res. A prior or contemporaneous expression of trust intention may be made, 1, by the transferor, 2, by the transferor and the transferee together, or 3, by the transferee with reliance therein or thereon by the transferor. Of course, after a transfer, the transferee as the owner may declare himself trustee. Gifts, Section 82. The settler cannot convey property as an outright gift and later execute a trust instrument declaring that the gift was actually in trust. Coleman versus Coleman, 1946. After acquired property, B, Section 83, where a voluntary trust intent is held and expressed by a person purporting to be the settler prior to her acquisition of the intended trust property, courts will probably find this to be a sufficient manifestation of intent to create a trust if there is some further manifestation of trust intent by that person, either by conduct or by words, after acquiring the property and consistent with the prior expression. For example, such subsequent conduct might occur by segregation of the property and making income payments to the intended beneficiary of a trust, thus established by declaration, or it might take the form of subsequent delivery of the property to another as a designated trustee. Klein versus Breyer, 1962. Number 5, trust must be intended to take effect immediately, Section 84. Another factor to consider in determining whether a trust has been effectively created is the time when the trust was intended to take effect. The settler must intend the trust to take effect immediately, even if subject to revocation and not at some future time. This assumes, as is usually the case with trust, that the would-be settler does not receive consideration that would make an express or implied promise to create a trust in the future enforceable. In the case of an intended declaration of trust, if the settler's manifestation indicates an intention only to become trustee in the future, there is no effective declaration of trust. Similarly, in the case of a trust to be created by transfer, if the settler merely manifests an intention to establish it by a transfer in the future, there is no trust. But for lack of present intention and for lack of the essential present transfer. Restatement 3D, Section 13 and 16. Note that under either of these circumstances, a trust does not arise later without further action at the contemplated future time. On the requirement of a transfer, see infra sections 265. Note also the close interrelationship between the requirement and the requirement of the trust intent. Example, sister writes to brother, quote, as soon as the harvest is completed, I want you to have my farm, which you are to hold in trust for your children. Or when I return from Europe, I shall make myself trustee of the cash in my safe for your children and shall invest it for them until the youngest reaches age 21. No trust is created in either of these situations because the intended trust is to take effect only at a future time. Subsequent action 85. A. If, however, there is an appropriate subsequent act or of transfer, or in the case of a declaration of segregating the res, that is consistent with the previously stated intention and with an intent that the trust presently take effect, a valid trust will then arise. Then, in the first example above, if sister delivers the deed to the farm to brother after the harvest is completed, a present transfer accompanied by the manifestation of present trust intention that is implied from this conduct together with the prior expression, this would cause a this would cause a valid trust to arise at that point, but with no relation back. Or in the second example above, if sister on her return put the cash in an envelope marked for brother's children, there would be an effective declaration of trust at that moment, even if sister should die before investing the funds. Effective postponing designation of essential elements, Section 86. If the owner of property executes an instrument purporting to create a trust, but providing that the beneficiaries, trustee or trustees are to be designated later, incomplete terms of trust are evidence that the settler intended a trust only in future, and there would be no present trust. Trust of future interest, Section 87. As long as the trust takes effect immediately, the trust res itself may consist partly or entirely as a presently existing future interest. Example, grantor deed or grantor deeds, red acre, to grantee for life, remainder to trustee in trust for friend. A valid present trust is created because friend has enforceable rights as beneficiary and trustee has present rights and trustee as has present rights and duties as trustee, such as to prevent waste by grantee, the life tenant. Example, father devises Blue Acre, quote, to First Bank in trust to pay the income to mother for her life, remainder to daughter. Daughter assigns her remainder to Second Bank in trust for friend. Daughter has also created a valid present trust because friend has enforceable rights as beneficiary and Second Bank has present rights and duties as trustee to prevent breach of trust by First Bank. This is good stuff. This is definitely good stuff. D, trust of a promise, Section 88. An unenforceable, i.e. gratuitous, promise to create a trust is in the future does not create a trust. There is neither a present transfer nor an intention to create a present trust. Example, settler executes and delivers to friend a promissory note stating, quote, I hereby promise to pay friend $10,000 to be held by friend in trust for certain stated purposes and beneficiaries. Assuming the promise is not for consideration, there is no trust. 1. Effect of consideration. 89. If consideration is given for a promise that is otherwise enforceable at law, such as by damages, excuse me, or in equity, such as by specific performance, then the intended beneficiaries' rights can be enforced. See Infra 293. The better view probably is that the promise itself being viewed as creating no actual trust for lack of present transfer, there is an enforceable right to have a transfer made and the agreed trust established at a later date. Another interpretation of the situation would view it as creating a present trust of a choice in action, such as, or i.e., with the enforceable promise as the res. Example, settler owns an enforceable promissory note from debtor for $10,000 and transfers it to friend as trustee for stated purposes and beneficiaries. Here there is a trust and res and a res, a, a choice in action. E, Savings Bank Trust, Toten's Trust, Section 90. Courts have developed unique rules where a person deposits her own money in a bank account in her own name as trustee for another. Realistically, such a deposit may not in itself manifest a clear intention presently to create a trust. The depositor may have intended to create no immediate interest in the designated beneficiary, but merely to have the funds go to him only in the event of the depositor's death. Nevertheless, most courts hold that presumptively such a deposit presently creates a valid, although revocable, inter vivos trust, sometimes understandably called a tentative trust. See Infra 418 to 431. Testamentary Trust 90, Section 91. Trusts that are to be created by will are effective despite the fact that they are not intended to take effect until the testator dies. One moment, please. So a checklist to determine sufficient trust intent. Number one is the intent. I do apologize for the delay. The intent manifested by words or conduct need not use the word trust. It is the intent expressed as a mere hope, wish, or suggestion that's considered precatory language, which we want to stay away from. Is the intent manifested while the settler owns or is transferring the intended res? Is the trust intended to take effect immediately? So these are the sufficient trust intents you want to determine. So trust property or res requirements. Number one, in general, Section 92. There are three generally stated requirements for the trust property or res. It must be one, an existing interest in property. Number two, capable of ownership and alienation. And three, sufficiently identifiable or identified. Number two, interest in property, Section 93. The res must be an existing interest in existing property, real or personal, tangible or intangible. The interest held in trust may be a present or future interest, possessory or non-possessory, vested or contingent. Restatement 3D, Section 40. A mere expectancy insufficient, Section 94. An interest that has not yet come into existence, a mere expectancy, cannot be a trust res because the settler does not have the property. Restatement 3D, Section 41. Example, daughter declares that she holds, quote, any property I may inherit from father end quote, who is still alive in trust for friends, children. Daughter has not created a valid trust, nor can daughter transfer such an expectancy to to trustee in trust. Compare if father had been dead when the transfer was made, however, there would be a valid trust because daughter's interest in the estate would be existing property, even if father's estate had not yet been administered. This is definitely good stuff to know. Exam tip. Watch out for an exam question in which the trust res consists of property that the settlor does not currently possess. A future interest, such as a remainder, can be held in trust because is a present it is a presently existing legally protected right and property. Although possession may be postponed until the future, however, a mere expectancy, i.e., not yet in legal existence, cannot be held in trust. Number 1, manifestation. Again, after acquisition, Section 95. If daughter again manifests her present intention by declaring a trust of the inherited property after it is acquired, this will create a trust at the time. See Section 81 through 83. But the later declaration is not retroactive to the earlier expression of intention. A potentially important point because it fixes the date for the existence of the trust, rights, and duties. See Brannard versus Commissioner of Internal Revenue, 1937. Number 2, consideration, Section 96. If a friend had paid consideration for daughter's declaration of a trust in assets to be subsequently acquired, however, the court would probably treat the transaction as a contract to create a trust when the assets are actually acquired. The contract can be specifically enforced even if daughter has changed her mind. See Infra 293. Exam tip. Remember that consideration is not required to create a trust. See Super 64. But it can cause an otherwise unenforceable gratuitous promise to create a trust in the future to be unenforceable under contract principles. See Infra 293. B. Equitable interest, Section 97. The res may consist of an equitable interest, such as the interest, such as the interest of a trust beneficiary, if assignable, can be transferred into another trust and held as the res of the second trust for the benefit of others. In such a case, the trustee of the second trust does not have legal title to the res. He has paramount equitable title, while the beneficiaries of the second trust are said to have subordinate equitable title. The equitable interest placed in the second trust may be a present or future trust, and if the latter, it can be vested or contingent as long as the local law recognizes the interest as transferable. Alienability, Section 98. Because trusts are created only by some form of transfer by the settlor, even if in the form of a declaration passing title from the settlor individually to the settler in her fiduciary capacity, it is usually a somewhat casually stated a standard doctrine that the interest held in trust must be alienable. Restatement 2D, Section 79. A. Common law, Section 99. A early common law, certain future interests, such as possibilities of reverter and contingent remainders, were non-alienable and therefore could not be transferred into a trust, although the retention of a reversionary interest in the trust estate after transfer by the trustee of a fee simple determinable or other interest in trust property that is less than that held in the trust was permissible. Today, however, in most states, all future interests are freely alienable and may be placed in trust. Where this is not so, the old disability remains. B. Inalienable property, Section 100. Certain other types of property are not alienable and hence cannot be transferred into trust, such as certain tort causes of action in some states, or the interest of a beneficiary of a spendthrift trust. See in for Section 460 through 489. 1. But note, strictly speaking, the standard doctrine referred to above applies to transfers into trust and not to whether inalienable property can be held as a trust res. Thus, if an inalienable cause of action arose in the trust, it could be held as a trust asset. Number 4, identified or identifiable, Section 101. The trust res must be specific property that is actually identified or is described with sufficient certainty that it is identifiable, i.e., can be ascertained from existing facts. Restatement 3D, Section 40, Cmte. Thus, it is often said that the trust property must be segregated, but the term is used to indicate the need for a certain identifiable res, not to preclude a trust of an undivided interest. Example, settler declares herself trustee of, quote, the bulk of my securities. The description is too indefinite and no trust is created, but a declaration is to, quote, all my securities but a declaration as to, quote, all of my securities except my U.S. Steel stock would be sufficient because by taking inventory of all settler securities on the date of the declaration and excluding the U.S. Steel stock, the identity of the trust estate could be established. A. Fractional interest, Section 102. The trust res may consist of a fractional undivided interest in specific land, such as quote, a 1/3 interest in Blackacre, or such as, quote, 1/2 ownership of my law library, end quote. United States Trust Company versus Commissioner of Internal Revenue Service, 1936. Similarly, an assignment of 40% of the funds in my savings account at National Bank to another as trustee should be effective to create a trust of an undivided interest in the account as it exists on the date of assignment. Share of fungible goods, Section 103B. Some doubt may still exist, however, where a trust is sought to be created in a portion of certain fungible goods, i.e., cash or goods, where each item is by its nature deemed to be the commercial equivalent of every other, such as barrels of oil or bushels of wheat of a certain grade or quality. Example, settler having $200 in bills in her pocket, or even an amount she is uncertain of at the moment, declares that she holds $100 of these bills for beneficiary. Is there a valid trust? The answer is probably yes, but the authorities still leave some doubt. 1. Segregation, Section 104. There should be sufficient segregation for this purpose if, as in the above example, or where a stated number of barrels or oil or bushels of wheat are to come from a particular oil tank or wheat bin. The trust property is identifiable as an undivided interest in, or is determinable fractional share of, a larger but identified or identifiable supply, a particular fund or mass of a fungible items. Some courts, however, may still require that out of the fungible mass, there first must be some appropriation of the specific items to be held in the trust. Obligor as trustee, Section 105. As a general rule, an obligor does not, by agreement with the obligee calling for a payment to a third person, become a trustee of what is simply his own debt. There is no identifiable trust res, no segregation of funds, as the debt remains merely a general claim against the obligor. Malero versus Cooper, Restatement 3D, Section 40 CMTB. Number 1, illustration, insurance 106. An insurance company, while holding the proceeds of a matured policy and paying interest, is not the trustee of the funds. The beneficiary simply has a general unliquidated claim against the company rather than a right to any particular asset or fund. This is true even where the proceeds are being held and paid pursuant to an annuity option or pension payment plan or similar arrangement, as long as no particular funds have been segregated and set apart by the company for this purpose. N. Ray Nyers, 1943. Note, if the company fails, the beneficiaries have no priority over other creditors because nothing is held in trust for them. McKay versus Paradise, Supra, Section 43. Likewise, if a beneficiary seeks modification of the agreement, even under circumstances in which a court of equity could modify the terms of a trust, the petition would be denied. McLaughlin versus Equitable Life Assurance Society, 1933. Illustration 2, bank accounts, 107, section. This principle has also been expressed in cases dealing with bank accounts. The problem arises where the bank is insolvent and the depositor seeks to establish that the bank was trustee of deposited funds in order to achieve some priority in distribution of the bank's assets. Trust funds held by an insolvent not being part of the insolvent's estate. Bank deposits, however, do not give rise to an identifiable trust risk. There is no segregation and no inferred expectation of segregation by the bank of monies deposited, and there is but a general claim against it for the amount deposited, plus interest. This has been held to be true even where the depositor called for the bank to hold the amount as trustee. People ex rel, Barrett versus Carroll, Alexander County Bank, 1936, and where the deposits have been specially marked or designated for a specific person or purpose, but in either case with no actual segregation of the funds involved. Example, deposits for transmission of credit, Legnity versus Mechanics and Metals versus National Bank, 1921, for payment of a foreign debt, Wallace versus Elliott. In escrow, Squire versus Nally, 1936, Ohio, and its special accounts. Payroll accounts, Blakely versus Brinson, are not trusts. Such special accounts probably create third-party beneficiary contracts, but not trusts. But see Infra 111. A few courts have been willing to find an identifiable trust risk in such cases. Guidus versus Island Refining Corp, 922, but this minority view has been criticized as perverting trust law to reach a desired result. A segregated fund, Section 108. A contrary result will follow if a trust were intended, where the bank did specially segregate the funds in question, such as by having the specific funds on deposit placed in a separate vault or separately invested. Obligee as trustee, Section 109. The rule in the preceding paragraphs apply where the bank is sought to be held as trustee of funds deposited. There is a little question that the depositor, obligee, may hold the debt as trustee for another. The deposit itself, the choice in action, is clearly an identifiable res. The depositor, therefore, can, by declaration or assignment, name herself or constitute another as trustee of a bank account. such as I hereby declare myself trustee of savings account number 76201 at XYZ Bank for the benefit of beneficiary. One moment, I'm going to drink a sip of water, please. Number one, Toten's Trust, Section 110. The usual problem presented by a deposit in one's own name as trustee for another, however, is whether the depositor really intended to create a trust, and if so, upon what terms. This is the so-called Toten Trust problem. See Infra 418. Number two, special deposits. Problems may develop with special deposits where the depositor later becomes insolvent and creditors seek to reach the money earmarked in the special account. For example, monies deposited in a special account to pay dividends to shareholders have been held to be trust assets belonging to the shareholders and therefore not reachable by the depositing corporation's creditors. In Re Interborough Consolidated Court, 1920. But in a few dubious cases, similar deposits to pay employee salaries or to pay coupon holders of corporate bonds have been held to be regular non-trust assets of the corporation and hence reachable by creditors of the corporation. Holman versus First National Bank in 1934. What constitutes sufficient trust res? Future interest, promise supported by consideration, equitable interest such as beneficiaries' interest in another trust, fractional interest in specific property, debtors' debt held by another, mere expectancy, unenforceable gratuitous promise, inalienable property, beneficiaries' interest in a spendthrift trust, fractional interest in non-segregated property, debtors' owned debt, parties to the trust. D. Number one, settlor or trustor, Section 112. In general, a person who owns a property interest may create a trust with regard to it and become a settlor. Restatement 3D, Subsection 3. Capacity 113. A settlor's legal capacity to create a trust is measured by the same standards applied to like non-trust conveyance. Thus, a settlor of a testamentary trust must have testamentary capacity, and a settlor of an inter vivos living trust must have capacity to make a similar type of non-trust inter vivos transfer. Restatement 3D, Section 11. The settlor of a revocable inter vivos trust must have testamentary capacity because such a trust is considered to be a will substitute. The settlor of a donative irrevocable inter vivos trust must have gift-making capacity, and the settlor of a trust established as part of a commercial transaction must have contractual capacity. Restatement 3D11, CMTs B and C. 1. Voidability, Section 114. Legal disabilities, such as minority or mental incompetency, may render the settlor's act void or voidable with the same consequences as any other void or voidable conveyance under appropriate law. Restatement 3D, Section 11 CMTE. Under some circumstances, trusts may be created or amended by conservators or holders of durable powers of attorney on behalf of settlors under disability. Restatement 3D, Section 11 CMTF. Number 2, qualifications, Section 115. In general, to have testamentary capacity, a settlor must 1. Be of legal age to make a will, 2. Suffer from non-derangement, insane delusion that affects the testamentary disposition, and 3. Be able to understand the nature and extent of her property, the natural objects of her bounty, the interrelationship of these, and the formulate and understand the disposition she is making. The settler of a donative irrevocable inter vivos trust must meet the gift standard, which is generally less settled than the will standard, but which is probably the same as for wills with respect to mental sufficiency and freedom from derangement affecting the transfer, and further requires the ability to understand the likely effects of an irrevocable transfer upon the future financial security of the settler and dependent family members. Rights and trust property after creation of trust, Section 116. Once a trust is established, the settler generally has only such rights or interests in the property as are reserved by the terms of the trust, such as most commonly a retained life estate or the express power to revoke and modify or both, or by operation of law. Restatement 3D, Section 63. Hence, complete title vests in the trustee subject to equitable interest, beneficial rights and powers conferred upon the beneficiaries, who may or may not include the settler, depending on the trust terms. Number one, modern trend, revocability presumed. Section 117. Under the UTC and by statute in several non-UTC states, such as California, inter vivos trusts are subject to revocation unless expressly declared to be irrevocable by the terms of the trust. CUTC 602A. Reversionary interest, Section 118. Even where no rights have been expressly reserved by the settler, if the trust or some interest in it is invalid, the res is excessive for the trust purpose, or the equitable interests have not been completely disposed of, a resulting trust exists in favor of the settler by operation of law. See Infra Section 1011 through 1020. 3. Mistakes or misconduct, Section 119. No right of enforcement in settler as such, Section 120. Unless the settler has retained beneficial interests in or powers over the trust, in which event she has the enforcement rights of a beneficiary, the general rule is that the settler has no right to bring proceedings against a trustee or others for enforcement of the trust. This is because the settler, as such, has no interest in the trust property. On recent trends in legislation, however, see Infra 781. Settlers' creditors, Section 121. Whatever beneficiary or whatever beneficial interest the settler retains, such as a right to income for life, may be transferred by her and can be reached by her creditors. Thompson versus Fitzgerald, 1941. Even if the trust provides that the settler is entitled only to such income or principal as the trustee, in his discretion, deems appropriate, cause, law, and numerous statutes indicate that the settler's creditors can reach the maximum amount the trustee could permissibly distribute to the settler. In Ray Shirley, 1997, and Vanderbilt Credit Corp versus Chase Manhattan Bank, 1984. Number one, exception, asset protection trust. Section 122. A number of states have enacted asset protection statutes that in some circumstances deny creditors access to settler retained discretionary interests. See Alaska statutes 34, 40, and 110. And then there's a code annotated title 12, 3570 through 3576. I think that's Delaware. Okay, section 2, retain powers, section 123. Creditors cannot reach the trust estate simply because the settlor reserved the power to direct the trustee regarding investments or distributions to others. If the settlor has retained the power to revoke, however, the cases are divided. Despite the rule as to retain discretionary interests, and despite many cases holding the creditors can reach trust property over which the settlor holds a general power of appointment, the traditional view of most courts have been that the settlor's creditors cannot reach the corpus of a revocable trust because of the incongruity of this rule in light of analogous principles. The distinct trend of cases and legislation is to allow such creditors to reach the trust corpus. State Street Bank and Trust Company versus Riser. 1979, Johnson versus Commercial Bank. 1978. This is also the view of the third restatement, section 25, and comment E and UTC section 505A1, and has long been the rule in federal bankruptcy. Number 3, fraud, section 124. In all states, creditors of the settlor can reach the trust estate if it is shown that the trust was created by a transfer that constituted a fraud upon creditors. See infra section 228. A fraudulent conveyance is one that it is made without adequate consideration by a person who is thereby rendered insolvent, or who made the transfer with the intent to hinder the defraud her creditors. Number 2, trustee. A, qualifications. Section 125. Any person or entity who has a capacity to acquire and hold property for its own benefit and has capacity to administer the trust may be a trustee. Statutes limit the right of some persons or entities, such as foreign corporations, to serve as trustees. Number 1, capacity to take and hold title. Section 126. In the absence of statute, anyone who has capacity to acquire or hold title to the particular property for his own benefit also has capacity to receive the property as trustee thereof. Restatement 3D, section 32. At common law, partnerships and other unincorporated associations were regarded only as an aggregate of their members, rather than as a separate entity, and the association itself thereof or therefore could not hold title to property or qualify as a trustee. Nearly all states today, however, recognize a partnership as an entity apart from its members. Thus, a partnership can hold title to property and can serve as a trustee, even in states that still follow the common law aggregate theory. A conveyance to a partnership may be construed as one to the partners individually. Restatement 3D, section 33, 2. Number 2, capacity to administer trust. The capacity to take and hold property as a trustee is not the same as the capacity to administer the trust. Persons who have capacity to take and hold title to the property as trustee may not necessarily have capacity to administer the trust. Thus, a valid transfer may be made to such a person to create a trust, but that person will not be allowed to administer the trust. I.e., to continue serving as the trustee. For example, minors or mentally disabled persons may validly receive property in trust, but because their contracts or acts are generally voidable, and because such persons are not likely to possess the requisite skill and understanding to perform the trustee's duties, the lack They lack capacity to administer an act of trust and will thus be removed by the court and replaced by another trustee. Restatement 3D, Section 32, CMT. C. Number 3, corporations, domestic and foreign, as trustees. Today, all states authorize the use of corporate trustees, usually by statute. A. Common law, Section 129. At early English common law, however, the court refused to allow corporations to serve as trustees, in part because the chancellors believed that they had no power to compel creators of the state to act, and also because of a belief that only natural persons should bear the fiduciary duty of a trustee. B. Foreign corporations, Section 130. In several states today, foreign corporations, i.e., those incorporated in other states, are denied the right to engage in trust administration, or as it is often provided by statute, quote, to carry on trust business, end quote, within the state. R.A. Shapiro, annotation, eligibility of foreign corporation to appointment as an executor, administrator, or testamentary trustee, 1969. However, such a flat prohibition, absent some justification, may be unconstitutional. Number 4, co-trustees, Section 131. Where 2 or more persons or entities are named as trustees, each must have the requisite qualification. If one does not, the right to act belongs only to the ones that do. In Ray Dorrance's will, Restatement 3D 34 CMTD, if the trust terms or purposes are construed as requiring a certain number of co-trustees for sound administration, the court will appoint an essential trustee to replace one who is disqualified or dies. Co-trustees are generally deemed to hold as joint tenants with right of survivorship. Number B, bonding, Section 132. Although there was no automatic or presumptive bonding requirement at common law, statutes in many states require trustees of testamentary trust to post a faithful performance bond. More recent legislation tends to require a bond only if a court finds a need for it. CUTC Section 702A. Number 1, court may order bond to protect beneficiaries' interests, Section 131. Courts of equity or probate or other appropriate court generally have the power to compel the trustee of any type of trust to post a bond if a particular risk is demonstrated, or if the trustee is involved in litigation with the beneficiaries in which there is a personal attack on the trustee for mismanagement of the trust, etc. Number 2, court may override waiver of bond, Section 134. This equitable power applies even where the settlor has expressly provided that a bond is not necessary if there is a direct attack on the trustee's performance or a material change of circumstances. Otherwise, the control probably will not order the trustee to post a bond, whether the settlor provided relief from bonding. Ex parte Kilgore, 1889. A court generally may also relieve or reduce an otherwise applicable bonding requirement. Please give me a moment. Number 1, rationale. This rule protects the settlor's intent and preserves the trust until its purposes are fulfilled. It presumes that the identity of the trust is less important than the carrying out of the trust purposes. In Ray McCrae's estate, 1928. Number 2, personal trustee cases, Section 136. In rare cases, the settlor may express an intent that The named trustee is only one acceptable to administer the trust, i.e. the personal trustee without whom no trust is desired. Here, the trust does fail for terminate if the named trustee declines to accept, is dead or is incompetent, or ceases to serve, and the court will not appoint a successor. Laurie versus Bright, 1929. Number 3, caution. Without trustee, an intended inter vivos trust may fail or for lack of delivery. Section 137. It should be noted, however, that the absence of a trustee may result in the failure of the attempted creation of an inter vivos trust because of the requirement of a present and effective transfer. See Infra Section 265. In other words, if there is no trustee, there is no one to whom delivery can be made. Without delivery, there is no transfer and thus no trust. Hence, the trust fails for lack of a transfer, not for want of a trustee. A. Attempted transfer to trustee to be named in will, Section 138. Thus, an attempted inter vivos assignment to the trustee to be named in my will fails for the lack of delivery and for want of a trustee to pass the title at the time of the purported conveyance. With no effective transfer, there is no trust. Frost versus Frost, Massachusetts, 1909. B, trustee disqualified. If there is an intended trustee to whom delivery with requisite present intent is made, but the transferee is technically disqualified by law from taking title, not merely disqualified from serving as trustee, the result is in doubt. A court may salvage the trust, possibly as a declaration of trust or by appointing a trustee, especially for a natural object of the transferor's bounty. Whitmire versus Heiligenstein, 1923. But supposedly, equity does not save defective gifts by treating them as declarations of trust. The question is unsettled, and the theoretical basis for a trust in such a situation is unclear. See Scott on trust, Section 31.5, Section 32.3, 4th edition, 1987. Testamentary trust, Section 140. This problem does not arise in connection with testamentary trust because no requirement of delivery of existence exists. The transfer requirement is satisfied if there is a validly executed will and the testator dies. No more is required. If the trustee named in the bequest or devised is predeceased, lacks capacity, or disclaims, or even if no trustee has been made or named, quote, I leave my residuary estate in trust for L for life, remainder to R, end quote. The trust is nevertheless good unless personal to the named trustee, and a trustee will be appointed by the appropriate court. In re estate of Hosher, Missouri, 1986. Exam tip. If you encounter an exam question in which the named trustee dies, refuses to accept appointment, or resigns, remember that the court will appoint a successor trustee unless it is clear that the settlor intended the trust to continue only so long as that particular trustee served. However, an attempted inter vivos trust that does not name a trustee may fail for lack of delivery. Title to trust res, Section 141. The trustee is said to have a bare legal title, meaning that it is devoid of beneficial ownership, i.e., the trust property is held for and on behalf of the beneficiaries in accordance with the obligations of the trust. A, source of title, section 142. The trustee of an inter vivos trust derives title from the trust conveyance. However, the authorities are split on whether a testamentary trustee derives title from the decedent's will or is merely nominated by the will and derives the title by judicial appointment confirming that nomination. The question is relevant where someone seeks to block the trustee's appointment, and the question may affect procedural matters or whether the trust or the estate then has title. In any event, the grounds for blocking an appointment are ostensibly at least the same as the grounds for removal of a trustee. See infra section 154. Relation back, section 143. Acceptance by the trustee of a testamentary trust relates back to the settler's death because the trust is treated as having been in existence from that date. Exam tip. The relation back rule is important to remember because it is possible for a trustee by accepting to become personally liable on contract or tort claims arising prior to the time he accepted. See infra section 807 through 823. Quantum of estate, section 144. Usually the trust instrument will spell out the nature and extent of the title or title conveyed. If it fails to do so, the court must determine the quantum of estate transferred. Under the traditional view, in such a case, the trustee takes title to real property only to the extent necessary to carry out the terms of the trust. Restatement 2D, section 88. The modern view, based on the implied powers and duties of administration, is that the trustee takes and needs the full title that had been held by the settler in both real and personal property. Restatement 3D, section 42. Example. Settler deeds, quote, to trustee upon trust for beneficiary for life. Does trustee have the fee or merely a life estate per alter v for beneficiary's life? Under the modern view, trustee will be deemed to hold in fee simple with a resulting trust, i.e. an implied equitable reversion in favor of settler. Under the traditional view, however, trustee will be deemed to have full legal title with a resulting trust in favor of settler. If trustee's power include a power of sale, as is typically the case, or if the implementation of his duties or powers otherwise require full title, such as to encumber, absent some such expressed or implied power, trustee must or might be deemed to have only a life estate for the life of beneficiary with the legal reversion left in settler. Number 2, trust estate not liable for personal debts of trustee. A, early minority view. In a few states, based on a theory that beneficiaries only had a cause of action against trustees rather than equitable title, the trust res was subject to execution by creditors for the personal debts of the trustee. The beneficiary's remedy in such state was to bring a separate suit in. The beneficiary's remedy in such states was to bring a separate suit in equity to enjoin the creditors by proving their beneficial ownership of the trust res. Giles versus Palmer, 1857. Modern view, section 146. Under modern view, however, the trustee has long been recognized in all states as having only a bare legal title, no beneficial interest, and hence the trustee's personal creditors cannot reach or satisfy their claims from trust property. Restatement 2D, Section 308, and Resection 3D, Statement 42, CMT-C. Number 3, effects of trustee's death. Death of sole trustee, Section 147. Although the trustee has only a, quote, bare legal title, it is nevertheless title. On the trustee's death, that title is generally deemed to pass to his estate subject to the trust. Thus, the trustee's heirs take no beneficial interest, and the trustee's surviving spouse cannot claim dower, courtesy, or a forced share in the trust property. Furthermore, the decedent's executor or administrator has no active administrative power over the property, but probably has a duty to protect it, and if necessary, see to the appointment of a successor trustee. The court will direct the transfer of title to a successor, who then has the power to administer the trust. Restatement 2D, Section 104. 1. Note, some statutes are contra and provide that on the death of a sole trustee, title is invested in the court or is suspended until a new trustee is appointed. Restatement 2D, Section 104, CMT B. B. Death of one of several co-trustees, Section 148. Co-trustees are presumed to hold title as joint tenants with the right of survivorship. Thus, on the death of a co-trustee, the title vests exclusively in the survivor or survivors. The law presumes, in the absence of circumstances indicating the contrary, that the settlor intended to have the survivor or survivors discharge the burdens of the trusteeship. Restatement 3D, Section 34 CMTD. If the instrument provides otherwise or the courts find contrary intent. However, this presumption does not apply and a successor co-trustee will be appointed. This may also be done if the court concludes that this is administratively more efficient or prudent, such as where the surviving trustee has a conflict of interest, often as a beneficiary. E. Disclaimer of resignation by trustee. Disclaimer 1, Section 149. Normally, a trust cannot be forced upon the designated trustee. Thus, one who has not previously accepted a trust or contracted in advance to do so can disclaim and refuse appointment as trustee for any reason or for no reason whatsoever. Restatement 3D, Section 35(2). It is said, however, that the trustee cannot accept in part and disclaim in part. If he accepts at all, he is deemed to have accepted the entire trust. This probably overstates the rule. The question likely turns on harm to the trust purpose or to a beneficiary who does not consent. For example, lower courts routinely allow a trustee to accept the trust, but to disclaim certain duties in the form of fiduciary powers that will have adverse tax consequences. Number 2, resignation, Section 150. Once having accepted appointment as trustee, a person cannot merely resign unless the trust instrument gives this power or unless all beneficiaries consent. Lane versus Tarver, 1922. Ordinarily, the trustee must obtain an appropriate court order relieving him as trustee. Until then, he must carry out and perform all the various trust duties, and he remains personally liable for the consequences of any defaults in the meantime. Restatement 3D, Section 36. Effect of unauthorized reconveyance. The trustee cannot escape his responsibilities or defeat the trust by reconveying the trust res to the settlor. The purported reconveyance may be treated as a nullity, or at most the reconveyance may effectively return legal title to the settlor, with the beneficial ownership remaining in the beneficiaries. The settlor would then hold title as constructive trustee for their benefit. Hinton versus Hinton, 1915. B, when resignation becomes effective, Section 152. Even if the trust instrument permits the trustee to resign, the resignation usually is not effective until a successor is appointed. The common law notion of no gap in succession and the interest of sound, secure administration require that legal title and duties remain in the trustee until taken on by another. The trustee assumed this obligation in accepting appointment initially. Removal of trust, F, Section 153. Unless the settlor reserves the power to remove a trustee or confers that power on some named or described beneficiaries or another persons, only a court of competent jurisdiction may remove a trustee. Restatement 3D, Section 37, UTC Section 706. 1. Grounds for removal, Section 154. Numerous grounds for removal are recognized, but the basic criterion is whether the trustee's continuance in office would be detrimental to the interests of the beneficiaries. Among the various grounds recognized are legal or practical disability, serious or repeated breach of trust responsibilities, including the duty to cooperate with co-trustees and the duty to render accountings or reports, refusal to give a bond as required, commission of a crime involving dishonesty, and conflict of interest not contemplated by the settlor. See Savage versus Galloway, 1948. Insolvency. Insolvency of the trustee is generally not in itself a sufficient ground for removal unless the court finds that the trustee's insolvency jeopardizes the welfare of the trust. Kelsey versus Detroit Trust Company, 1933, in Michigan. Fred Hutchinson Cancer Research Center versus Holman in Washington, 1987. B, animosity, Section 156. Disagreement or tension between the trustee and one or more beneficiaries is not a ground for removal unless the animosity jeopardizes the sound administration of the trust. Compare Aiken versus Dow, 1983, in Texas, with Renaker versus Renaker in 1987. C, Settler, appointed trustee. 157. Generally, the courts are less inclined to remove a trustee named by the settlor than one appointed by the court. This is particularly true if the alleged ground for removal, such as a conflict of interest, was one known to or anticipated by the settlor. Jones versus Stubbs, 1955. N. Ray Crawford's estate, 1940. Section 2, removal by beneficiary, Section 158. If under the trust terms, the beneficiaries have the power to modify the trust or to terminate it and compel the trustee to transfer the properties to them, see Infra 953 through 980, they have a power to remove the trustee directly because it would be pointless to require them to change the terms of the trust, terminate it, and immediately create a new trust upon the same terms with a new trustee. Compare UTC Section 706B4. Grounds for removal of trustee: legal or practical disability, serious or repeated breach of trust responsibilities, failure to render accounting, such as, or refusal to give bond, commission of crime involving dishonesty, conflict of interest not contemplated by the settlor, insolvency unless welfare of trust is jeopardized, and animosity between trustee and beneficiaries unless welfare of trust is jeopardized. G, merger of title where sole trustee is also beneficiary. Where the trustee, the holder of legal title, and the beneficiary, the holder of full equitable title, are or become one and the same person, the legal and equitable title merge. defeating the trust and creating a fee simple absolute in the trustee beneficiary, who thus holds outright and free of trust. Restatement 3D, Section 669. Number 1, attempt to decline trusteeship, Section 160. This is really, this part right here, merger of titles, when it's talking about the trustee, who is the holder of the legal title, and also the beneficiary, which would give them ownership to be of the full equity of the title. This sounds like something I've been hearing in regards to like an absolute trustee. But let's continue reading. They say keep reading and we'll find the answer we're looking for. Okay, so it says 1, attempt to decline trusteeship, Section 160. If the sole trustee is the sole beneficiary at the outset, it may be argued that the title merges immediately and no trust exists. Therefore, it has been said the trustee beneficiary cannot decline the trusteeship and preserve the trust, but the third restatement position is contrary. Restatement 3D, Section 69 CMTD. Number 2, non-identical interests, Section 161, where the interests are not identical, as where the trustee does not hold exactly the same quantum of interest, legal and equitable, there is no merger. This arises frequently where there are multiple treaties who are also the beneficiaries. As a general rule, the existence either of multiple treaties or of multiple beneficiaries or both preclude merger. Blades versus Norfolk Southern Railway, 1944. Example, obviously the scenario, quote, settler to son and friend upon trust for son, nephew, and niece, involves no merger because son's legal and equitable interests are not the same. Son has a 1/2 legal interest and a 1/3 equitable interest. Example, if the conveyance is, quote, settler to son and friend upon trust for the son and nephew, son's interests as trustee and beneficiary are not still merged, although son has a 1/2 legal and 1/2 equitable ownership. Most courts hold that son and friend's joint judgment is necessary to the management of son's interests as beneficiary, and the legal title and duties of both extend to nephew's beneficial interest. Restatement 3D, Section 69 CMTC. A few cases, however, have held that there is a merger with respect to son's equitable interest, the trust then consisting only of nephew's 1/2 interest. See Bowles versus State Trust Company, 1867. Example, settler to son and friend upon trust for son and friend for life, and then to nephew and his heirs involves no merger. Each co-trustee holds for the benefit of both during their joint lifetimes. When the first co-trustee dies, a court might hold that there is then a merger of the life estate and the survivor. Reed versus Brown, Supra, Section 18. However, this result is dubious at best. And a conveyance, settler to son and his heirs upon trust for son for life, remainder to friend, might suggest a merger of son's equitable life estate into the life estate part of son's legal fee, creating a trust only of the remainder interest was probably not what was intended because son's legal and equitable title are not equal. There should be no merger, and active duty should prevent execution by the statutes of uses. Okay, going back up here to this diaphragm, it says determining when legal and equitable titles merge. Okay, so you have S to A in trust for A. The result is merger. The rationale would be holder of legal title A and holder of equitable title A. So holder of legal title is A, and holder of equitable title is A. So he's the trustee and beneficiary and are one and the same person at outset, trustee and beneficiary. Okay, so S to A in trust for B. B dies, leaving A as her sole heir. Sole heir. S to A in trust for B. B dies, leaving A as her sole heir. It's a merger because holder of legal title A becomes holder of equitable title upon B's death. Okay, so it says S to A in trust for A for life, then to B. B transfers her interest to A. That is also a merger because holder of legal title A becomes holder of equitable title upon B's transfer. So another scenario would be S to A in trust for B. A dies, leaving B as his sole heir. That is also a merger. Holder of equitable title B becomes holder of legal title upon A's death. So S to A in trust for A and B is no merger because legal and equitable title interests are not identical and has entire legal interest. I'm sorry, A has entire legal interest and 1/2 equitable interest. Right, because he has equitable title because the trust was given to him as trustee. I'm sorry, he has legal title because the trust was given to him as trustee, but for the benefit of B. Okay. Well, not but for the benefit of B, but for the benefit of A and B. So that's kind of like a scenario with us. We being the settler of the SPC, we would give our living man the title as the trustee. So actually we will be up here as a merger because we will have the title as trustee for A and for whoever our beneficiaries are as well. So, or we would just say that we have no beneficiaries and this would be for the purpose of just a transfer of the trust or whatever. And then we would put that trust in another trust that does have other beneficiaries or whatever. This is just my theory and me thinking these things through. Okay. So to A in trust for A and B is also no merger. S to A and B, so the settler puts 2 trustees in charge. So A and B in trust for A and B. So they both have legal and equitable interests for life. Then to C. Okay, so it says legal and equitable interests are not identical. A and B hold legal interest in fee and life estate and equitable interest. Okay, so it says S to A and B in trust for A and C is also no merger, meaning although A has 1/2 legal interest and 1/2 equitable interest, A and B's joint management is required, right? Because they have to share the duties of the trustee. Okay, so S settler leaves to A and B in trust for A and B. No merger. It says, although A and B seemingly have identical legal and equitable interests, each both holds for benefit of both. Okay. They behold for the benefit of both. All right. I'm just going to take a break for water. Okay. A, no merger where several trustees are also the beneficiaries. Section 162. Settler to son and daughter upon trust for son and daughter creates a valid trust, no merger. Restatement 3D 69 CMT Blades versus Norfolk and Southern Railway. Supra, settler probably intended son and daughter to jointly manage the equitable interests of each, i.e., each co-trustee to hold for the benefit of both. Again, some authorities have disagreed, arguing that there should be a merger in this situation, the quantum and nature of the estates being identical. Probably the question is better viewed not as a technical one of merger, but as a question of attempted termination by consent of all beneficiaries, such as under the Claflin Doctrine, if it is applicable in the jurisdiction. See Infra 954. B, note, some statutes now confirm that intended declarations of revocable trust are not defeated by merger. See comment controversy over controversy over whether a merger has taken place arises most frequently when a creditor is pursuing the beneficiary's assets. The creditor will argue for merger so that she can satisfy her claim out of the beneficiary's legal share of the estate, which is usually more practical and effective than attempting to levy on a beneficiary's equitable interest. Number 3, beneficiaries. Necessity of beneficiaries. Number 1, private trust. To create a private trust, as distinguished from a charitable or if recognized, an honorary trust, see Infra 169 through 167, the settler must name or otherwise describe one or more beneficiaries, individuals, or eligible legal entities capable of acquiring a property interest and becoming an obligee. An intended trust will fail if it has no beneficiaries. Without a beneficiary, there is no one capable of enforcing the trust, and there must be for a valid trust. And there must be for a valid private trust, and it therefore fails. Exam. Recall that a trust will not fail for the lack of a trustee. However, a trust cannot exist without someone to enforce it. Thus, a beneficiary is necessary to the validity of every trust except charitable and honorary trusts. If a trust fails for lack of beneficiary, a resulting trust in favor of the settler or his successors is presumed. A, provision satisfying beneficiary requirements, section 164. It is sufficient to satisfy the requirement that there be at least one beneficiary if there is one or more of the following: beneficiaries named by the trust terms. 2, beneficiaries are so described as to be presently identifiable from intrinsic facts. Evidence of intrinsic facts is admissible, such as a fact of independent significance in the case of a will, see will summary. Or 3, beneficiaries to become ascertainable at a future time for those of my issue living 20 years after the death of X, as long as they will become ascertainable, if at all, within the period of the appropriate rule against perpetuities. Modest authority requires that there be at least one presently identifiable beneficiary. Unborn beneficiaries, section 165. This requirement is satisfied even if some, or by the better view, all of the beneficiaries or classes of beneficiaries are presently unborn. Restatement 3D, section 44, but see the dubious anomalous case of Morrisman versus Commissioner of Internal Revenue, 1937. Number 2, beneficiaries to be selected by a trustee, section 166. It is even all right If the beneficiaries are to be ascertained by the exercise of the trustees or another's discretion, as long as under traditional doctrine, the class among which the selection is to be made is reasonably definite or will become so within the perpetuities period. On the required definiteness of classes, see infra section 204. Trustees' awareness of intended beneficiaries, section 166B. The trustee need not actually know who the designated beneficiary is, as long as the beneficiary is capable of being identified when necessary, such as where the trustee is handed a sealed envelope at the time the property is transferred to the trustee who agrees to hold in trust for persons named therein. C, effective lack of beneficiary, section 168, where a private trust fails for lack of a beneficiary or for lack of properly ascertainable beneficiaries, there is a resulting trust in favor of the transferor, his heirs, or other successors in interest. See infra 1011, Union Trust Company versus McCon, 1927. Unless consideration was paid to the transferor for the transfer, trustees of Methodist Episcopal Church versus trustees of John Square Evangelic. I don't know why I'm so tongue-tied today. Evangelical Lutheran Church, 1896. Trustee who paid consideration allowed to retain property beneficially, and see infra section 293. Charitable trust, section 169. Identifiable beneficiaries are not required for charitable trust, and the Attorney General or a similar public official enforces such trust. See infra section 502. Number 3, honorary trust, section 170. Many jurisdictions allow the voluntary carrying out, but absent the statute not the enforcement of the purpose trust or honorary trust, trusts that are neither charitable nor private. In fact, even if allowed at all, they are not recognized as real trusts. In the strict sense of the term, they are a device usually intended to allow, generally without enforcement, the carrying out of certain objectives that are not private and that fall short of being charitable. The classic example is an intended trust for or an impermissible bequest to one's pets. Other honorary trust purposes have involved the maintenance of graves, now usually permitted by statute, or the funding of masses, now usually a religious charitable purpose. Example, testator bequeaths her residuary estate, quote, to brother in trust to care for my dog and cats. The trust is clearly not charitable because it is not broad enough to be charitable because it is only for testator's pets. Contrast a properly charitable trust for stray dogs and cats, infra section 550. Nor is the purpose enforceable as a private trust because there is no beneficiary capable of enforcing it. The beneficiaries are the pets, but see infra section 167 or 176, I'm sorry. Strict view, section 171. A few American jurisdictions still appear to refuse to recognize such a transfer as a trust of any sort and hold that the intended purpose fails and cannot be implemented, even voluntarily, by the transferee. Brother in the above example, who holds on a resulting trust for the transfer's testator's heirs, the intended trust also has been held to violate the common law rule against perpetuities at its inception, as the lives in being plus 21 years cannot be measured by animals' lives. See Eaton versus Miller, 1969. Invalid despite wait and see statute. Lenient view, Section 172. A leading English case and many American decisions have recognized this type of disposition as an honorary trust, although it is not enforceable as a trust. C. N. Ray Dean, 1889, but C. N. Ray Shaw, 1957, refused to extend the doctrine that is, for some appropriate purposes, such attempted but defective trust will be deemed to confer an unenforceable power upon the transferee to allow him to carry out the intended purpose if he is willing to do so. Restatement 2D, Section 124. Restatement 3D, Section 147. And UTC, Section 409. In the absence of legislation, honorary trusts probably cannot last for over 21 years because of the rule against perpetuities. In Ray Estate of Gay, 1903. 1. Effect transferee may carry out purpose, Section 173. If and so far as the transferee voluntarily carries out the purpose, he will be allowed to do so, and no one can object. But if he fails to do so, or after he carried out the purpose, he holds the property or what is left of it on a resulting trust for the transfer or transfer's successors in interest, such as their heirs. Example, same facts as in the example above, except the jurisdiction applies the honorary trust doctrine. Brother is allowed to carry out testator's purpose, and if he does, testator's successors cannot complain, at least not for 21 years. See super or until brother has rejected or abandoned the purpose, but brother cannot retain the purpose for his own use. Number 2, interest created. A traditional view, Section 174. Under the traditional, quote, honorary trust, end quote, doctrine, where it is recognized, the interest under testator's will could be described as follows. The residue of testator's estate ultimately belongs beneficially to her heirs by resulting trust, subject to a power in brother to apply if he wishes funds only to the care of testator's dogs and cats. B. Third restatement view, Section 175. The third restatement views brothers as a trustee with a usually non-mandatory power exercisable for a stated or reasonable time to apply trust property for the designated purpose. A reversion in testator or his successors or her successors and a right to enforce brothers' administrative duties is implied by law regarding an excess or remaining trust property. C. UTC view, Section 167. Under the UTC, the transferee of an intended trust for pets, brother in the above example, is considered a trustee with a mandatory power to apply trust property for the designated purpose exercisable until the last surviving pet dies. UTC Section 408A. All other type of honorary trusts are enforceable under the UTC for 21 years by a person named in the trust instrument or appointed by the court. UTC Section 409. Distinguish. If precatory expressions such as I hope, I wish, or request are used, and if no trust intent is shown, the transferee can disregard the suggestion and retain the property outright. Thus, if the transferee wishes, he may carry out the transferor's suggestion, not as an honorary trust, but because he is free to do so as owner of the property. See Supra Section 71. Exam tip. If you encounter a fact pattern or exam on if you encounter a fact pattern on your exam in which the transferor purports to leave her property in trust for the care of her pets or for the maintenance of her cemetery plot, think honorary trust. If the named trustee is willing to perform his duties, he will likely be allowed to do so. But if he is not willing, or once the purposes have been fulfilled, such as the pets have died, a resulting trust arises in favor of the transferor or her successors. Also remember that in the absence of a statute, many jurisdictions will void an honorary trust on this basis of the rule against perpetuities if its duration may be more than a human life in being plus 21 years. Who may be a beneficiary? Section 177. Broadly, any person, natural or artificial, who is capable of taking and holding title to property may be a beneficiary of a private trust. Restatement 3D, Section 43. 1. Minors incompetent, Section 178. Thus, minors and incompetents may be and often are beneficiaries because they have capacity to hold title. Number 2, unincorporated associations, Section 179. At common law, a trust in favor of a partnership or other unincorporated group would fail unless the gift was construed as a gift to the partnership of groups or members. Kane versus Gibney, 1879. Entity theory, Section 180. The trend today is to treat unincorporated associations as legal entities for at least some purposes, such as to sue and to be sued in the group name and to hold title to property. Accordingly, they now generally can be trust beneficiaries. Restatement 3D, Section 43, CMTD. Non-charitable associations, Section 181. Nevertheless, a trust for the continuing benefit of a non-charitable association may present special problems under the rule against perpetuities because it has neither the immunity of a wholly charitable trust, nor is it tied to in duration to a period measured in relation to human lives and being. In Ray Estate of Shaw, 1969, trusts to, quote, pay income to the Masonic Lodge held void. Capacity required to serve as trustee or to be beneficiary. Type of person. So you have type of person, the trustee over here, beneficiary. This is good stuff, y'all. So capacity required for trustees to take and hold title and to administer trust. A beneficiary just needs to take and hold title. Okay, so you have the type of person. Are adults a type of person? Yes. Can they be trustees? Yes. Can they be beneficiaries? Yes. Can a corporation be a trustee? Yes. Can a beneficiary be a corporation? Yes. Can a partnership be a trustee? Yes. Modern view. Can a beneficiary be a partnership? Yes. Or minor and incompetent. So can a minor or incompetent be a trustee? No, but see Super 127. Can a beneficiary be minor or incompetent? Yes, they absolutely can. Who is a beneficiary? The problem of incidental benefits. Not every party who stands to benefit through operation of a trust is regarded as a beneficiary of it. If the trust only incidentally benefits an individual or entity, the nature or the natural or legal person is not a beneficiary and cannot enforce rights thereunder. Example, if a trustee is directed to invest a portion of the trust estate in bonds of a particular corporation, the corporation is not a beneficiary and cannot sue to compel the trustee to follow the directions. Scott on Trust, Section 126. The beneficiaries can, however, surcharge the trustee for damages, if any, result from the breach of duty and failing to follow the valid trust terms. Example, if the trust provides that the trustee is to employ X to perform services for the trust, authorities presume, absent contrary evidence, that the provision is for the best interest of the beneficiaries and not to provide the benefit of employment to X, who benefit is merely incidental. Under this interpretation, X would have no right to enforce the provision directing her appointment. Only the beneficiaries would have cause to complain if the trustee failed to follow the settler's instructions and they were damaged as a result. In Ray Platt's will, 1931, from Wisconsin. The presumption may be irrebuttable if X is to provide legal services to the trustee. Example, suppose the conveyance is, quote, debtor to friend and trust to pay the creditors of debtor. If this is construed as a trust, some cases hold it as a mere agency. It should be considered a trust for the benefit of debtor, the debtor transferor with power in friend to pay debtors' creditors. The creditors are not beneficiaries and have no right to enforce payment unless the trust grew out of the creditor's composition or compromise agreement. Perhaps a third-party beneficiary if the dealings were contractual in nature. See contract summary. Otherwise, the trust would be terminable at will by debtor as sole beneficiary and settler. Exam tip. It is important to remember that not every one who benefits from a trust is considered to be a beneficiary. The trust must operate directly to benefit the person. Individuals and entities incidentally or indirectly benefited cannot enforce trust provisions. D, requirement that beneficiaries be identified or members of a reasonably definite class, Section 181. A valid private trust requires beneficiaries capable of enforcing it, and those beneficiaries must be ascertained and ascertainable when the trust is created or assuredly become ascertainable, if at all, within the period of the rule against perpetuities. See Infra 246 and see Future Interest Summary. The purpose of this requirement of identifiable beneficiaries is ostensibly, at least, to assure that the trust is or will be enforceable, which in turn ostensibly requires or will require persons who are identifiable as beneficiaries or as members of a reasonably definite and ascertainable class of beneficiaries. Restatement 3D, section 44 through 46. Number 1, beneficiaries unascertained when trust created. A beneficiary need not be identified or even identifiable at the date the trust is created. It is sufficient if the instrument gives a formula or description by which the beneficiary can be identified at the same time when enjoyment of his interest is to begin. That time, however, must be within the period of the applicable rule against perpetuities, i.e. under the traditional common law rule. It must be certain at the outset that the beneficiary will either be ascertainable so that his interest will vest within the property, or that the interest will fail by that time. In either event, here will assuredly be an ascertainable beneficiary and an ability to enforce the trustee's duties either via the expressed interest or by way of a resulting trust. Example, settlers transfer, quote, to trustee in trust for sister for life, remainder to sister's children, is clearly valid. This is true even if sister had no children at the date the trust was executed. Whatever children sister later has will necessarily be ascertainable by the time enjoyment of their interest is to begin on sister's death. If there are no children, there will be a resulting trust for a settler or his successors in interest. Note, the same also should be true for 1, a trust executed for the settler or settler's wife at the time when the settler was still unmarried. 2, a trust solely for afterborn children of the settler, or even 3, a trust for a corporation to be formed by the settler or within 21 years. Status until beneficiaries ascertained. 185. If the as yet unascertained beneficiary or beneficiaries are the sole beneficiary or beneficiaries, such as S to T in trust for the children of B when B has no children. 1. Minority trust invalid. Section 186. A few decisions have held such a trust to be invalid. Morrisman versus Commissioner of Internal Revenue, Super 165, but this result is highly questionable and may have explained by the fact that the case involved taxation at a time when tax doctrine itself seemed ill-equipped to deal appropriately with the situation presented by the trust if it were recognized. Number 2, majority resulting trust. 187. The more sound and usual view is that the trust is valid and enforceable. Restatement 3D, Section 44 CMT C, and that until the beneficiaries are ascertained, the trustee holds tentatively on a resulting trust for the benefit of the settler or for the settler's heirs or other successors in interest. The resulting trust is subject to an executory limitation, which displaces the equitable reversionary interest, i.e. the resulting trust, and places equitable title in the intended beneficiaries or beneficiaries if and when they come into existence, unless the settler has reserved the power of revocation. The express trust cannot properly be defeated by a subsequent agreement between the settler and the trustee. To attempt to do so would be a breach of trust. C, purported trust remainder to heirs of settler or life beneficiaries. 1. Doctrine of worthier title. Section 188. Suppose settler deeds to trustee and trust for brother for life, remainder to my heirs. In most modern jurisdictions, settlers' heirs are remainder beneficiaries, individually unidentifiable with enforceable interest nevertheless. So long as settler lives, the doctrine of worthier title invalidated a remainder that was limited to the grantor's heirs. Therefore, in any jurisdiction that may still follow the doctrine of worthier title, there is or presumptively is no remainder in the heir, but instead there is or presumptively is a reversion in settler himself. When the doctrine has been treated as a rule of construction, i.e. a presumption, it has generally been applied to personality as well as land. As a rule of law, i.e. as prohibition, it applied only to real property. See future interest summary. Number 2, rule in Shelley's case. Section 189. Suppose settler deeds or devises Blackacre to trustee and trust for brother for life, remainder to the heirs of brother. Today there is a remainder interest in brother's heirs, unidentifiable beneficiaries of a nevertheless enforceable interest in a definable class so long as the brother lives. Restatement 3D, Section 49, CMTA 1. Under the rule in Shelley's case, now apparently indistinct as a remainder until a remainder limited to life estate holders, heirs was not recognized. Under some circumstances in those jurisdictions, that follow the rule, brother, not brothers, heirs would have the remainder. Thus, brother would have had complete equitable title, merging into full legal title if fee, in fee. See future interest summary. Technical rules of common law, doctrine of worthier title. So you have this table is going over the doctrine of worthier title. And on this side, it talks about Rule and Shelley's cases. So it says remainder to trustees, heirs invalid. Transfer has a reversion. Transfers to T, S transfers to T in trust for for life, then to my heirs. A has a has a life estate. S has a reversion. Abolished in most jurisdictions has been treated as a rule of construction, i.e. raising a rebuttal presumption. A has a life estate and S heirs have a remainder. So on the side of Rule in Shelley's case, the remainder to life estate holders, heirs invalid becomes a fee simple. If S transfers to T and trust for A for life, then to A's heirs. A has a fee simple, abolished in nearly all states. A has a life estate, and A's heirs have a contingent remainder because A's heirs are not identifiable until death A. I'm going to stop there reading, and I'm going to pick up when I come back for another recording. My eyes are getting heavy, and I don't want to keep making this video too long, so I'm going to stop. I appreciate you all for listening again. Thank you for your support, and make sure you share this video with those that you know, like, and love. Those that you want to help become free. With that being said, it is your girl, Empress ShayMarie, and I'll see you guys on my next recording.